Okay, so let's talk tort law. And a tort is basically a breach of duty that has been imposed by civil law. We talked about your constitutional protections and how the Constitution, the Bill of Rights, protects you from the government. Well, tort law is what protects you from other parties. Tort is filed by the wronged or damaged party, not the government. So you would file a tort against someone else. You might file a tort against a company, an organization, whatever it might be. But the tort is filed by the wronged or the damaged party. There are three kinds of torts. There are intentional torts, negligent torts, and strict liability torts. I'm going to talk about each of those today. Torts, so there's no jail time when it comes to tort law. What happens with tort law is when you win a tort case, you are compensated for your damages. So there's no jail, there's just money damages. So looking at intentional torts, the first one we're going to talk about is assault and battery. So a battery is an intentional touching of another person in a way that is harmful or offensive. An assault is in fear of an imminent battery. Let's say that you're in a bar fight and you swing and you hit somebody. Well, the swing is the assault, the contact with the body is the battery. So assault and battery frequently goes hand in hand. Doesn't happen that way all the time. Let's say that you're at a party and there's that person that you have a beef with for whatever reason. Don't do this in real life. You see that person, you walk across the room, they see you, and you come up and you swing and you hit them. Assault and battery. Let's say that you swing and miss. That's just an assault, no battery. Let's say that they're turned around talking to somebody else. And so you go up behind them. Again, don't do this. So you go up behind them and you punch them in the back of the head. Well, that's just a battery, no assault. They didn't see it coming. Assault and battery also doesn't need to be person-to-person contact. If the party is holding something and you come up and rip whatever it is out of their hand, because this is in contact with them and you come in contact with the cup, this is still an assault and battery. Assault and battery also is a tort that is also a crime. A couple of these are torts that are also crimes. False imprisonment is the intentional restraint of another person without cause or without their consent. There was a case that just came up in the news in the last week or so. A judge, and I want to say it was Michigan, there was a high school class that was visiting the judge's courtroom on a field trip. One of the students fell asleep in the courtroom. Might have been a little bit boring. May have had a long night the night before, but whatever reason it was, the student fell asleep. The judge did not take too kindly to that, had the student put in a holding cell, and did not release her until the field trip was over. That judge is now on the hook for false imprisonment and is also on the hook, the parents are suing, for intentional infliction of emotional distress as well. And that is extreme and outrageous conduct that causes serious emotional harm. Think about this. You're on a field trip with your class and in front of other students, you're humiliated, you're put in a jail cell, you don't know when you're getting out, you don't have access to your parents or any person of authority other than the person that put you in there. That's going to cause some trauma. And in order to have intentional infliction of emotional distress, there has to be some serious emotional harm that comes with it. It's not just that person made me feel really bad. There has to be something more to it. Trespass is intentionally entering onto land that belongs to someone else or remaining on that land after being asked to leave. Malicious prosecution is the intentional and malicious pursuit of a criminal legal action without probable cause. It's not just, so malicious prosecution isn't just that you were a suspect in a crime and they let you go, or they got the wrong guy, or something like that. You have to show that there was that they pursued you, that the prosecution pursued you without probable cause. Fraud is injuring a person through deliberate deception. Fraud is also a tort and a crime. We also have torts that relate more specifically to businesses. Tortious interference with contractual relations. Two kinds: interference with a contract and interference with a prospective advantage. Interference with a contract happens when the defendant improperly induces a third party to breach a contract with the plaintiff. Here's what you have to show. First of all, you have to show that two parties were engaged in a contract, and the defendant knew that there was an active contract between the defendant and the third party, and the defendant improperly induced the third party to breach the contract or made performance of the contract impossible to the plaintiff's detriment. Okay, so you have to show there was a contract, the third party knew about the contract, and the third party did something to make the one of the parties breach the contract. Interference with a prospective advantage is just like interference with a contract, except you don't have to show that there was a contract. You just have to show that there was discussions that was leading to a long-term business relationship. So there were talks and contracts. There had been negotiations that took place. You have to be able to show that there was more than just the hope of a profit, you have to show that there was relationship that had started that was moving very quickly toward being a long-lasting business relationship. Third party came in, did something to cause one of the parties to break off negotiations to your debt. Additional intentional torts. Oh, and I didn't mention, so intentional torts don't mean that you intended to harm. Intentional in the term torts means that you intended to take the actions that you took. So you don't have to show, it's not about doing somebody wrong. It's doing something that caused harm at some point. So probably the most common tort is defamation. There's two types of defamation. There is slander, which is verbal, and libel, which is written defamation. And in order to prove defamation, you have to prove four things. First of all, that there was a defamatory statement that was made. You have to show that that statement was false. It was communicated to someone other than the plaintiff. If you say something incorrect about me to me that is derogatory and negative, and I correct it, it's not defamation. And then finally, you have to show that there's injury, that something that you were damaged as a result of the defamatory statement. Maybe you lost your job, maybe you were suspended from work, maybe you lost out on a business opportunity. So there was some kind of, maybe you were suspended from work while it was investigated. So you have to show that there was some kind of injury that resulted from the defamation. Slander and libel per se basically are alterations of slander and libel that include statements that are so harmful that you don't have to prove injury, you just have to prove that they were made. So slander per se, false statements about sexual behavior, crimes, contagious diseases, professional abilities, don't have to prove injury. Libel per se, written statements that relate to criminal or sexual conduct, contagious diseases, professional ability, don't have to prove injury. They are assumed to be harmful. So you just have to prove that the other party made those statements. Okay, so let's take a look at defenses for defamation. The first one is opinion. If you say something is your opinion, it generally can't be proven true or false. It's just what you think. And so generally, if something is editorialized in some way or very clear that it's an editorial, it does not amount to defamation from a legal perspective. A related defense is in cases where a statement of fact clearly should not be taken literally. You think about like programs like Saturday Night Live, where there's a lot of spoofing and a lot of farcical humor. Generally, if a lawsuit were to arise from something like that, it wouldn't go anywhere because clearly if the audience knows that it's not intended to be serious. Public personalities receive less protection from defamation. They generally can only win a defamation case by proving actual malice. And actual malice means that the defendant knew that the statement was false when they made it, or they acted with reckless disregard of the truth. And when I talk about public personalities, I'm talking about politicians, celebrities, actors, people who put themselves out in the public forum. Another defense for defamation is privilege. There's two kinds of privilege: qualified privilege and absolute privilege. A defendant has qualified privilege when when it is important for them to speak freely. Absolute privilege would be like a witness testifying in a court or a legislature or some kind of official body. They can never be sued for defamation. And also, qualified privilege is when you're in a situation where you have to say what you think you might know. So for example, let's say that I'm a nurse and I think that my colleague who I'm working with is taking illegal drugs. I have a legal responsibility to report that information to the supervisor. If it turns out I was wrong, I wasn't speaking in order to be malicious, and generally I have qualified privilege that in that situation, I had a responsibility to speak to the supervisor. Now, if in that same scenario, I didn't tell the supervisor, but I went and told a bunch of our friends, that I don't receive privilege for. I receive privilege because of the context, and that would be qualified privilege. Some additional torts: invasion of privacy, also referred to as intrusion into seclusion, and that occurs when somebody intentionally intrudes into the private affairs of another person. So you are in a situation where you expect privacy and somebody intrudes upon that privacy or invades that privacy. A lot of times people think of like peeping, looking into someone's house without their permission, things like that. That is intrusion upon seclusion. Appropriation of someone's name or likeness is the commercial use of someone's name, image, or likeness without their permission. Public disclosure of embarrassing personal facts is the publication of the private affairs of another person when those disclosures would be highly offensive to a reasonable person. So just because you know something private about somebody doesn't mean that you can go and tell the world. If it's something that a reasonable person would know that they would want to keep disclosed, then you have an obligation to. All right, moving on to negligence. Negligence is physical harm that is not intentionally caused. You can be negligent by doing something, or you can be negligent by failing to do something. And intention is not required with negligence. Typically happens, we see it a lot in places of business, and there are 5 elements that the plaintiff needs to prove. First of all, that there is a duty of due care. The defendant has a legal responsibility to the plaintiff. There's a breach of that duty. The defendant's conduct actually caused the injury. It was foreseeable that conduct like the defendant's might cause that type of harm, and the plaintiff has been hurt or suffered measurable loss. So if you think about a grocery store, and the grocery store is a public place, the grocery store has a duty to keep the environment safe, keep the aisles clear. If there's a spill, somebody should clean it up. And so if I go in the grocery store and am in the pasta sauce aisle and somebody has spilled a jar of pasta sauce and I slip and fall on the pasta sauce, and because of that I get a bump on my head and I have to go to the hospital, I have a negligence claim against the grocery store because they had a legal responsibility to clean up the spill, maybe to warn me, maybe to stop me from going down that aisle. The defendant's conduct, or the fact that they didn't clean up the spill and I slipped, caused the injury. It's foreseeable that to leave something wet on the floor can harm someone if they slip and fall, and I was injured. So that's how the elements of negligence work. Now, I may be partially at fault. Let's say, for example, that they had done everything that they should have done. So the pasta sauce falls off the shelf. Immediately, 2 employees are called. They block off the aisle to make sure that no one can go down the aisle. And I, as an irritating customer that I am, but burst through. I'm in a hurry. I need to go get my pasta sauce. And as a result of my breaking through or going past the barricade, I am partially at fault. That is referred to as either contributory or comparative negligence. Whether it's contributory or comparative depends on the state that you live in. In a contributory negligence state, the law says that if the plaintiff is even slightly negligent, so if it's even a little bit the plaintiff's fault, they recover nothing. And comparative negligence is when the plaintiff can recover something, but they are partially responsible. And so what happens with comparative negligence is, let's say that I'm suing for $100,000 and the jury says, okay, the store is responsible, but Christina is also responsible too. And we think that Christina is 60% responsible and the store is 40% responsible. Then what I receive, my award is reduced by 60%. So I would only receive $40,000 out of a $100,000 award. So that is comparative negligence. California is a comparative negligence state. Assumption of risk. If the situation is inherently risky or there is an obvious danger, you can't complain if you're injured. If I go and I sign up for snowboarding lessons, if I am injured while learning to snowboard, it's not the snowboard school's fault. It's my fault. I will say that there's a caveat with that. If the snowboard instructor acted with gross negligence, like if they pushed me down the hill when I wasn't ready for it, in that case, they're probably responsible. An act of God, if the harm was caused if the harm was due to an unexpected natural event, if I'm walking through a parking lot and I get hit by lightning, it's not the parking lot owner's fault that I was hit by lightning in their parking lot, so I can't sue them. That was just an act of God. And then vicarious liability is when one party is liable for the negligence of another. Employers are frequently liable for the actions of their employees. That's vicarious liability. Strict liability is when the law imposes a much higher level of liability when the harm results from ultra-hazardous acts or defective products. What is an ultra-hazardous act? And you might ask, well, it's something that is extremely dangerous or a dangerous activity. Harmful chemicals, toxic chemicals are ultra hazardous. Explosives, ultra hazardous. Keeping wild animals, extremely dangerous. Any activity where the danger to the public is especially great. If my neighbor is keeping a wild tiger and the tiger is in captivity, it's in a cage, it's been a great tiger for all of its life, even if I bathe myself in meat and walk over to the tiger's cage and go in to pet the tiger, the owner of the tiger is still responsible because it is a strict liability activity. And so the plaintiff doesn't need to prove duty, breach, or foreseeable harm. They just have to prove damage. So when we look at products, when products are defective, so when we look at defective products, the plaintiff has to prove harm, but they don't have to prove how the manufacturer was careless. And there's 6 requirements for a plaintiff to recover. First of all, the product has to be in defective condition when the defendant sells it. And the defendant can be the manufacturer, the distributor, or the retailer. The defendant has to be normally engaged in the business of selling, so it's got to be a merchant, and it's either the person who sells or distributes the product. The product has to be unreasonably dangerous to the user or consumer because of the defective condition. So just because the product doesn't work right does not necessarily mean it's a strict liability issue. Strict liability means the product is dangerous. The plaintiff has to incur physical harm to self or property by using or consuming the product. The defective condition has to be the proximate cause of the injury or the damage. And the product has not been substantially changed from the time it was sold to the time the injury was sustained. So if I take a product, go home and modify it, and then it harms me, that's not on the manufacturer or the reseller, that's on me. With strict liability, you do not have to prove that the defendant's conduct was unreasonable. You don't have to prove privity. Privity basically means that you are one of the parties to the contract. So let's say that I am riding in a car, and I'm riding in a car with my friend who owns the car. And the car has a defective condition. The airbags go off without anything, just while we're driving down the road in normal driving conditions. Even though it's my friend's car, I still have a strict liability or a defective case for a defective product, even though I was not a party to the car purchase. I was still injured by the product. These rules apply even when the seller has exercised all possible care in the preparation and sale of the product. So even if the seller does everything that they're supposed to do, this is a risk that sellers and manufacturers have to take. And the user or consumer has not bought the product or entered into any contractual relationship with the seller. Again, I don't have to be the buyer. I might just be somebody who is using the product by virtue of context or geography. When we look at damages that come from torts cases, there's two types of damages that we typically see: compensatory damages and punitive damages. Compensatory damages are damages that are designed to recompense. So it's money that restores a plaintiff to the position that they were in before the injury. Typically, this includes things like medical expenses, lost wages, pain and suffering. Those are typical compensatory damages. Punitive damages, on the other hand, are damages that are intended to punish the defendant for conduct that is extreme and outrageous. So compensatory damages are standard. Punitive damages are special. Not everyone gets that. You have to show that the conduct by the defendant was extreme and egregious. And there's three guideposts that courts use when awarding punitive damages. First of all, they look at the reprehensibility of the conduct of the defendant. They look at the ratio between the harm suffered and the award. And they look at the difference between the punitive award and civil penalties used in similar cases. Punitive damages generally are capped at treble damages. Capped damages simply means that there is a maximum amount that you can get. Economic damages are things like lost wages. Non-economic damages are things like pain and suffering. Lost wages typically don't have a cap. Pain and suffering do, and punitive damages have a cap. Punitive damages are typically capped at treble damages, a 3-to-1. So if you sue for $100,000 in compensatory damages, the most you're going to get for punitive damages is going to be $300,000. And so that's what a cap on damages means. You also, in most cases, when you sue, you only get to go to court one time under what's called the single recovery principle. And basically what that means is that if I am in a car accident and I sue for lost wages because the doctor says I'm going to be out of work for 6 months, and pain and suffering, and repairs to my car. So I sue for 6 months of lost wages, and I happen to be out of work for a year. Well, once the case is settled and I'm out of work for a year, I don't get to go back for that extra 6 months. I get the 6 months because that was what I asked for in the lawsuit. So typically with a lawsuit for damages, you want to make sure that you recover everything that you're going to need using because you only get one chance to recover damages. And so that's it for torts.